Hello everyone, I'm Indu Krishnaswamy from the Center for Law and Policy Research, Bangalore. This is the last part in the four-part podcast on the discussion around the Uniform Civil Code in India. In the previous three parts, we reviewed the constitutional, judicial and political history of the UCC. In this episode, I'm here with my colleagues Disha Chaudhary, Satya Prasun and Vineet Krishna to debate and discuss the relevance of a uniform civil code in today's India and the frameworks available within which it could be implemented. So, why are we talking about the Uniform Civil Code in 2017? Vineet, could you please start us off with a historical perspective on this topic?
Thanks, Indu. First, I'd like to direct the listeners of this podcast to read the text of Article 37 in order to understand exactly what we're talking about when we refer to the directive principles of state policy. Article 37 puts forth two things. It says that the principles under the directive principles of state policy have to inform the way the state governs the country. It also makes a mention about its enforcement. While the courts are asked to not enforce these principles, some directive is given to states to implement these principles while they govern the country. Now, the reason why it's important to look at the directive principles of state policy in the first place when we're talking about the Uniform Civil Code is that it is an argument that is brought out by people who support the Uniform Civil Code. So the argument goes like, the Uniform Civil Code is part of the Constitution, it's a directive principle, hence this is enough reason for us to think of its implementation. Now let's go back briefly and understand how the directive principle of state policy first comes into Indian constitutional thinking. Initially, when the constitution framers were talking about fundamental rights, there existed nothing like the directive principle of state policy. We would just had a set of rights, draft rights, that had the potential to be included in the Constitution of India. At some point later, the framers of the Constitution realized that there were some articles under the fundamental rights section of the Indian Constitution which were best kept as non-justiciable, and so the fundamental rights section was divided into two parts: the justiciable part and the non-justiciable part. The non-justiciable part later on gets renamed as the Directive Principles of State Policy. The nomenclature is borrowed from the Irish Constitution of 1937, where there is a mention of the term Directive Principles. And this was then borrowed and put under Part 4 of the Indian Constitution. So what are the directive principles of state policy broadly? These are socio-economic rights. But one, while glancing through these principles, realizes there are some articles which don't seem to be logically socio-economic rights. So for example, the Uniform Civil Code and the cow slaughter provisions, after a glance through the constitutional history and the Constitutional Assembly debates, one seems to understand that these were put into the directive principles of state policy part only as compromises. Taking a step back, what role does the directive principle of state policy play in Indian politics, or rather, what did the framers of the Constitution think of them and their role in Indian politics? Well, essentially, they wanted politicians and civil society to mobilize these principles while talking about how the country was supposed to be governed. And for some reason, we find that some of these provisions are talked about, such as the Uniform Civil Code and the cow slaughter, but others are ignored.
Why do you think that would be the case? Like, why is it that the country is focused on two of the many DPSPs that have been drafted in the Constitution?
I think how the constitution makers envisaged is that all of these directive principles are important in achieving the aim of welfare state. But how politics has shaped these directive principles is that they focus on these two directive principles. The one is cow slaughter and the other is uniform civil code. Maybe it is because these are ways in which you can regulate or target practices or dietary customs of a particular religious minority, and it is the politics which is driving the conversation around these two directive principles. Also, I just want to add that although all of these are directive principles should be of equal importance, but how courts have looked into it, I think there is a presumptive hierarchy in which directive principles are more important. Some directive principles which directly complement fundamental rights I think courts have given them higher priority. These are followed by some of the directive principles which ensure socio-economic justice, and these would be statutes relating to equal pay for equal work, or special statutes for protecting women, or special statutes for disadvantaged classes like SCs and STs. And again, there are third kind of directive principles where there was a lot of disagreement between constituent assembly members over the content and form of it. And uniform civil code, I think, will form in the third category.
So you look at Uniform Civil Code, that falls into the compromise category of this hierarchy of 3 levels within the DPSP.
And I
Yes.
think that could also probably explain why you still have controversies, right? These were problems that
Right.
were not. If you look at the two parts of the directive principle that you just mentioned, the socio-economic parts, the equal pay, etc., and then you have these controversial articles. Back then, there was no in the Constituent Assembly. There wasn't much controversy about these other articles that you talked about, equal pay, etc., and all of that. But the Uniform Civil Code and Carlslotter was certainly controversial, and the framers of the Constitution decided to defer the question for future politics and parliaments to decide upon. And in some sense, we can see the controversy that we have now as a longer duration of finding a solution to this problem.
I would actually say that Satya's first point of the hierarchy being about directive principles that sort of supplement fundamental rights. One of the reasons for the feminist movement to advocate for a uniform civil code was to be able to bring personal laws within the domain of fundamental rights. Because it was there that most of the violations happen as far as women are concerned. So when it comes to the Uniform Civil Code, it's very important to discuss the context within which this debate around it rises, right? It's not that there's a dearth of civil laws that are applicable to citizens of India. We have a Civil Procedure Code, we have the Transfer of Property Act, we have a Contract Act, we have a Guardianship Act. It's only in the domain of personal laws that you see some sort of a lack of uniform principles governing civil relationships of marriage and family. So the Uniform Civil Code debate does tend to gain supremacy in the context of gender justice primarily, because as far as women of these religious communities are concerned, the codification of these practices, the lack of actually, has led to a lot of very patriarchal practices being in place, and the women were not involved to a large extent as far as setting the norms of these practices are concerned, right? They're only the victims. So for them, the Uniform Civil Code is some sort of a means to uphold their constitutional right of equality over their religious identity, to sort of detach them from just a religious identity, to see them as an individual who is entitled to the same constitutional freedoms as any other
citizen of the country. Yeah, which makes sense. So I think then that is what we are driving at here, which is if we go down the route that national integration and gender justice are the two goals for UCC, because national integration from the historical perspective, gender justice based on the feminist movement that we have going on currently, then would we say that the concerns around national integration that we see today are the same as what we saw in 1947, which is when it was raised the last time around? Are they relevant?
I think the question of national integration or national unity, however we want to call it, takes on two different senses compared with the current context and compared with the early years of the Indian Republic. Of course, while the constitution was not made in a vacuum, there were two important things that were happening at the same time. One was, we gained independence. The second was you had religious-based violence related to partition. And lots of academics have made claims that both these factors, more with the partition events that happened during constitution making, had a huge impact on how different articles of the constitution ended up being included into the text. So national unity during the debates on Uniform Civil Code was certainly a rationale that was brought up by members who supported the Uniform Civil Code. And national unity, of course, we are also working in the context of a large religious community which is pretty insecure, which suddenly finds itself in a Hindu majority community.
So this is the partition that happened in 1947.
That's right. This is the partition.
Okay.
And it's pretty clear that many of the framers of the constitution had to act statesman-like. They had to take into account the fact that certain communities have insecurities about certain parts of the constitution. And of course, the Muslim community had their reservations with respect to different things, and they certainly voiced their opinions about the Uniform Civil Code. While we don't see it in the debates, it's pretty clear that the Uniform Civil Code is also one of the articles where compromise was used,
Right.
where the framers of the Constitution, um, in some sense, compromised on the true principles that they believed in, as espoused by Uniform Civil Code, in order to gain a certain acceptance from the religious community so that they feel secure. And of course, right now we don't talk about territorial integrity when we say national integrity, but back then, national integrity meant territory because India's states had still not been formed. It was not clear where the borders would be, etc. So, national integrity literally meant physically national integrity. To use this argument in the contemporary sense might be problematic because we don't have, or at least most people don't think that the territory of India is under stake when we're talking about religious communities and their rights. That being said, yeah, Disha, you wanted to say something?
Yeah, so I mean, the not the territorial integrity bit, but if you see present day political scenario, I think it does mirror to a certain extent the environment that was post independence during the constitution making phases, because there is again this overarching Hindutva force in play, and most people argue that the UCC debate has been hijacked by them, and the fear that a uniform civil code may be a sort of a vehicle for Hinduization of the entire nation may in fact get religious communities to further strengthen their practices as a retaliation for fear of being subsumed under this one homogeneous Hindu identity.
Wait, if I understood you right, were you saying that there was a similar sort of Hindutva?
No, I mean that the
Hinduizing
communal
audience?
aspect of the problem, like post independence, there were some communal tensions, primarily with regard to the Muslim community, right? Those are seen present day context. You see them rising to the same, if not to the same level, but to a greater level as far as the Muslim personal law debate goes, because emphasis tends to shift on codification of Muslim personal law instantly, and they seem to see it as a threat on their religious community.
But
They
I
don't.
guess what you're saying is that to a degree substantiated by what's happening in the courts, right? Because we are seeing the debate of the UCC in the court as well. And we're seeing that through various cases that are passed through the court system.
Yes, Indu. So it is strange at one level that while politics will always respond to these kind of cleavages, but judiciary has also played into that mold in the sense that if we look at various cases where the judiciary has invoked uniform civil code, in all of these cases they have invoked it to promote national integrity or strengthen nationhood. Starting from Shah Bano, which was about Muslim women's right to maintenance, to Sharla Mudgal, where a Hindu man, where the case was if a Hindu man can convert to Islam just for marrying for the second time. These were questions. These were purely legal questions which could have been answered, but in both of these cases, the court very vociferously observed that there is a need for having a uniform civil code to strengthen nationhood. It was even followed in some of the in cases as recently as 2015, when in a case called ABC versus NCT, which was about the Christians' right of inheritance or guardianship. Sorry, Christians' right of guardianship. They said that it is time that the nation should think about having a uniform civil code because that would strengthen nationhood. So it is surprising that courts, rather than looking at it from the perspective of gender justice, have invoked national integrity as a reason why we should move towards uniform civil code.
But there is ambiguity around this invocation of national integrity being the reason for application of UCC. But based on what Disha has said in the past of all of these various laws that are in place, it sounds like, and also what you have just given us in terms of the history in the court, gender justice does seem to be one of the goals that can be attained through UCC, or is that just again a slight misinterpretation of what is possible legally in terms of gender justice?
No, the UCC, of course, the support for the UCC was in quest for gender justice under the Indian legal regime. because the belief is that your religious identity, the religious identity of a woman, cannot be the reason for denial of human rights that are guaranteed by the constitution.
Right.
And often you see the debate that does tend to rise is between maintaining the multiculturalist identity of India versus gender justice. Where do you? But it's not that you have to choose either of the two, and the courts have demonstrated that quite well. I mean, if you look at Shah Bano's example, there the courts did go into the practices of Islam and whether Islam permits grant of maintenance under Section 125, which of course led to a whole lot of communal issues later. But a similar case in Daniel Latifi, which is again a 125 claim by a Muslim woman, there the courts have said that the questions of basic human rights need not only rely on religious or social practices when we are deciding them, because the constitution guarantees certain rights which must be upheld over and above all of these, because social justice is an acceptable principle of every religious community.
Yes, of course.
So it's the argument that you do find in favor of not relying solely on the UCC as far as rights of securing rights of women are concerned is that of reasonable pluralism, where you can maintain your multicultural identity, but at the same time you negotiate the claims of gender justice in a manner that you have other provisions like Article 15.3 of the Constitution, which says the state can enact laws particularly in favor of women, subsequent to which you do have statutes like the Protection of from Domestic Violence Act, the Prohibition of Child Marriage Act, the Anti-Dowry Acts, where you can read or interpret these in a manner that does further the cause of gender justice without having to wait for the implementation of a uniform civil code to sort of uplift the position of women within these religious minorities.
Right, right. So what we are saying again here is the UCC is not the only way forward. There is there are
is
other
scope for, I mean, creative interpretation of existing laws or enacting more legislations instead of just trying to push for a uniform civil code as far as gender justice is concerned.
And then national identity and integration, though it is another commonly espoused cause for UCC, is not necessarily as relevant today as it was in 1947, though some of the causes and reasons why it was discussed then continue to exist today, whether it being inflated by the conversations or whether they're actually as intense as they were is still debatable. But national integration and integrity is more accepted today. So it's not the need of the hour, a UCC for national integration.
I would not say that it's national integrity as a concept plays different kind of role in different contexts. If you're talking about, say, the problem of indigenous defense production, all right, then national unity, national integration, and the question of the territorial borders of India being protected comes into question. So it's not that this argument has no value at all. It just depends on where it is deployed. So if it's deployed in the case of the Uniform Civil Code, it's the only way it can be relevant is if you talk about national unity in some broad abstract sense of citizenship. But certainly not in terms of territorial integrity. I don't think the point is that if we don't have a uniform civil code, we're actually going to have some sort of law and order problem. Maybe that's true, I don't know, but is it on an all India scale? I'm not sure, but certainly not the territorial boundaries of the country. The second thing which I forgot to mention when I was talking about integrity before was that ultimately the relationship between national integrity and uniform civil code is an empirical one. It's something that we can, I'm not sure of whether studies exist about other jurisdictions where people have found that there is a direct relationship between national integrity or unity with the presence of a uniform civil code. Of course, it might be hard to establish a causal relation, but maybe even a correlation could be insightful.
I'd also like to add something. Even as far as the gender justice aspect is concerned, there's this sort of open-ended question with regard to personal laws. The argument is that unless you codify these personal laws, they will not be amenable to writ jurisdiction before the Supreme Court. But then you have Article 13 in the Constitution, which says custom is also law. So the debate around whether the Supreme Court can actually utilize Article 13 in a manner so as to bring personal laws within the domain of fundamental rights still again remains this question that people are asking, whether you really do need to have a uniform civil code or can we navigate our way through this.
Right. Okay, so let's just summarize, as what we've said is, okay, gender justice and national integrity, there's no black or white solution here of whether UCC is the way forward or not, because it could help, it might not help, it might actually promote it. This is, if you look, this all depends on the angle and perspective you take
Are these
with
the
respect
only two?
to this.
Are these the only two conceptual prisms by which the Uniform Civil Code is articulated in India? National integrity.
These are the two primary
two
questions
primary ones?
that take prominence over everything else, because it's where most of the retaliation is faced of sorts, either from religious minorities or the idea of having one homogeneous Indian identity.
I think it's also this thing of pluralism, which is very,
which is why,
very, yeah.
like, to whether in giving into these arguments you're going to sort of lower the position of religious and pluralistic minorities, or deny them the practices that are so core to their community.
The courts definitely seem to think that, which is, in terms of gender justice, there seems to be this repeated take a throwaway note on UCC. Like if you had a UCC, we wouldn't have to debate this.
So I think there's a lot of confusion even within the court on what is meant by codification.
Right.
So the position at this point of time is that all religious laws are codified except Muslim personal law.
Yeah.
And so all the other personal law for all religion except Muslims can be judicially scrutinized, and if they are violating fundamental rights, they can be struck down. This process of codification can be done by just codifying Muslim personal law, and we should not, and it can be done without jumping to a uniform civil code. And if we codify Muslim personal law just as we have codified other religious laws, then all the discriminatory practices or gender unjust practices will become can be reviewed by the judiciary. And also, while we are codifying it, there would be legislative scrutiny also, which would ensure that some of these blatantly discriminatory practices will not be passed by the legislature.
And this we're talking about all laws that are codified, not necessarily for a specific community, right?
Yes.
The laws of any community.
Yes,
that
so
are
we are
codified.
not just talking about religion, but we should also think about one way of thinking about gender justice is codifying and having separate laws for all religion which are codified, and also for some of the tribal and cultural groups.
Right.
Without thinking of UCC in an abstract sense and thinking that we can have an all-inclusive code which will do justice to the intergroup plurality and would be gender just at one. Again, the question also is that we should also look at how codification within Hindus have been done, because that is taken as a template to push for gender justice. That are some of these practices really achieve gender justice or not has to be looked into on its own merit.
So yeah, so we have talked codification, we've talked national integrity, we've talked gender justice, UCC, the other laws that are available to achieve at least gender justice, the political and the judicial conversations that are taking place around UCC. Now, if you go down this one path, which is not necessarily the one that we will execute on as a country, if we wanted to implement UCC, what would be the changes required, and do we have a template? Has something been done earlier along these lines that we could reuse?
Well, Disha seems to know what I'm going to say, but still disagrees with me. But nonetheless, I think we can look at the right to education as a similar example. Of course, the issues are different. What is at stake is also very different. But with the right to education, we saw that it was part of the directive principles for the longest time. And we suddenly find in the early 90s, the court thinks of this particular provision as a fundamental right and does so formally. And later on, the legislature too, Parliament too, makes it a fundamental right. And a couple of years later, an enabling legislation is also brought into fact. So it might be the case that the Uniform Civil Code, I think this approach, or rather this trajectory of the future is highly unlikely. But what could certainly happen is supporters of the Uniform Civil Code will be happy if the Uniform Civil Code is lobbed into the fundamental rights, and some sort of legislation is brought about. So this is what I think. I think this approach is highly unlikely, but nonetheless, this is how the right to education became a fund and an act as we see today.
I think that if the politicians are sincere about Uniform Civil Code, they should at least begin by floating a first draft of Uniform Civil Code. This discussion on Uniform Civil Code for the past 70 years has gone out without a first draft on what would uniform civil code entail. So that is something which can be the starting point of this conversation.
Do you
I
want to have the last
actually
word?
agree with Satya because unlike the right to education, there are no divisive forces in play in the context of right to education, right? Unlike the Uniform Civil Code, I'm sorry. So if the lawmakers do come out with a draft, at least it may sort of allay the fears of some people who think this is going to be one majoritarian Hindu code. If you show on paper that what you intend on enacting is actually a comprehensive code that will apply to people across the board without any particular community's practices gaining prominence, then there may be a feasible way of bringing this in play.
And we will have to leave it at that. So, thank you, Vineet. Thank you, Satya. Thank you, Disha. So, here we hope to see you again on our podcast channel. And for us at CLPR, this is goodbye. You could follow us on Facebook, Twitter, and visit us at CAR India, SC Observer, as well as Center for Law and Policy Research. Thank you.